Good evening, friends. I hope you are all enjoying. So, today I have come live to discuss the recent judgment, rather, yesterday judgment pronounced by the bench headed by our next Chief Justice, Dr. Chandrachud, in case of the state of Jharkhand versus Shailendra Kumar Rai, wherein Supreme Court, after noting the derogatory test performed on the woman by the medical board in regard to the sexual intercourse, made some remarks and has given certain directions with regard to that so-called two finger test in their parting remarks. So, before proceeding with the parting remarks by the Supreme Court in the said judgment, I will like to explain little bit about what the case in actual was. The case relates to the November 2004 in the Jharkhand, where a man entered into the house of a girl, forcibly raped her, sexually exploited her with the threat that if she shouts, he will kill him. And as a natural phenomena, she cried for help. On this, the man, that is the respondent herewith, poured kerosene oil on her and set her on fire. Her family took her to the hospital, where ultimately she died, succumbed to the burn injuries. And the session court, that is trial court, convicted him for the offense of rape as well as murder under section 302 and 376. But the High Court acquitted him on the ground that the family member of the deceased and other private witness given up their statement and turned hostile. While discussing this matter, the points raised by the criminal defendant or the respondent that the dying statement recorded by the police officer is not admissible in the eyes of the law. The court dealt with this issue and held that under section 32 of the Indian Evidence Act, there is no particular type of performa to the extent that the evidence should be recorded in a particular form. And also, the court categorically concluded that it is not always the magistrate who has to record the dying statement or death statement or dying declaration, whatsoever it may be called. So, the statement recorded by the police officer, signed by the family members and the doctor at that time, and even the fitness certificate statement regarding the fitness of the deceased given by the doctor at that time is sufficient and can be relied upon, legally relied upon. So, court also took note that at the time of medical examination, the medical officer examined the deceased and categorically stated in her report that she conducted two finger test and found that her vagina was loose and she might having intercourse earlier also, or she is habitual of sexual intercourse. The two finger test or per vaginal examination is held to be contrary to the dignity of the woman several times by the Supreme Court. After noticing that still this test is being performed to determine the sexual behavior of the woman, court has issued specific direction, set aside the judgment passed by the High Court, and upheld the judgment passed by the Session Court, convicted the man. So, what the court say, rather, I would also say, I have already discussed on the issue of sexual assault and last on the issue of abortion, the judgment by the Supreme Court. So, the time is changing. Everyone has right to choose what he or she may like, to live the life to the fullest. The concept of the marriage has also changed. People have started living in live-in relationship. In the marriage also, some time it is said by either of the couple that they want do not want to conceive, rather they want to have an emotional attachment. So court took notice of these things and held that the dignity and privacy of the individual is most important. He or she has the freedom to choose his or her sexual partner. Even in the Joseph Sign case, Supreme Court has set aside the criminal prosecution for the adultery. So now, without going further, I would say, and I agree with the Supreme Court that with the changing circumstances, one has to change his or her mindset, and one is having complete freedom to enter into sexual relationship with anyone. So even if a female is sexually active, that does not give any man right to enter into sexual intercourse with her against her will, against her wish. If anyone indulge into sexual intercourse against a woman without her consent, then it falls under the section 375 of IPC, that is, it amounts to rape. So, Supreme Court has noting Supreme Court has noted these things and issues certain directions. After noting down the earlier judgment passed by the Supreme Court in Lillu versus State of Haryana, wherein Supreme Court has held that two finger test violates the right to privacy, integrity, or dignity. The court has further noted that, as I stated earlier, whether the woman is habitual to sexual intercourse or habitual to sexual intercourse is irrelevant for the purpose of determining whether he has been sexually assaulted or rape has been committed. The so-called test is based on incorrect assumption that the sexually active woman cannot be raped. Nothing could be further from the truth. A woman's sexual history is wholly immaterial while adjudicating whether the accused raped her. The sexual history of the woman is immaterial. It has no place in determining whether she has been raped or not. In this regard, Supreme Court has noted that certain guidelines have been issued by the Ministry of Health and Family Welfare in cases of sexual offences. These guidelines prescribe the use of the two-finger test or pre-vaginum test. Despite the issuance of the guidelines, the test is still carried out. So the Supreme Court has issued directions to the state government as well as union government to ensure that these guidelines may be circulated to all government and private hospitals, to conduct health workshop to the healthcare provider so as not to indulge into these types of tests. And further, Supreme Court said to review the curriculum of the medical students, medical schools, and to delete from the textbook these two-finger test or per vaginum examination, as this test violates the dignity, privacy, and integrity of a woman. So, Supreme Court said if any person conducts two-finger test or per vaginal examination on the rape victim or the sexually assaulted woman, it will amount to the professional misconduct. Misconduct, rather, the word used is misconduct, not professional misconduct. So, as the doctors, like the lawyers, are governed by the professional code, so they can be proceeded against professionally on account of misconduct on the ground of violation of the directions issued by the Supreme Court in the present judgment, as well as violation of the guidelines issued by the Union of India. I again repeat, the per vaginum examination or the two-finger test is violative of the fundamental right granted under Article 21 of a woman or the rape victim, sexually assaulted victim. No one can say that she is sexually active, habitually sexually active. So one has entered into sexual relationship with her on account her active sexual behavior. If he or she entered into a sexual intercourse against her consent, then it is a rape, and the statement of the victim, along with other circumstances, is sufficient to convict the accused or the criminal defendant. The two-finger test is violative of the right, dignity, integrity of the body of the woman. So, workshop has to be conducted. People has to be make vigilant about this. So my only motive to come live with this discussion is to clear certain legal facts. Thank you very much and goodbye.